My name is Michelle Bell, and I'm going to be comparing two legal cases seen in the TDSB regarding special education. Why are the legal implications of special education such an important topic to be knowledgeable of as a teacher? Special education programs foster and promote the success of students with special needs. If one defines an inclusive and equitable classroom as one that values the success of all of its students equally, students with special needs need additional support in order to succeed alongside their peers. Thus, exceptionalities, inclusivity, and accommodations all go hand in hand when it comes to the student success of those with special needs. The legal cases I examined were both within the Toronto District School Board because that's the board that I want to be working in the future, so I thought that it would be beneficial for me to do cases that were looked at in my specific board. In light of the importance of the implementation of successful special education programs in schools, as well as the importance of students with special needs having access to these programs, I chose two cases in which a child's participation in such programs was challenged by parents. So the Ontario Special Education Tribunal is brought in while the ministry is responsible for making sure that children with special needs have programs and accommodations available to them, but when the parents have exhausted all of their means of appealing their child's identification as having special needs or of participating in these programs placed by the ministry, that's when the matter is presented to the Ontario Special Education Tribunal. So the cases and their facts. Case number 1 was JD and RH versus the Toronto District School Board. December 24, 2001, the Education Act was used as the foundation for many arguments made in the case. The TDSB argued that the parent had not exhausted all rights of the appeal and that the matter dealt with the program issues rather than issues surrounding actually whether or not the child should be identified as having special needs or the placement of the child itself in the program. So the TDSB argued that the case should not be presented to the tribunal because the Special Education Appeal Board had not been established, and so the parents had not exhausted all other means of appeal as per the regulation of the Education Act. So they thus argued that the appeal to the tribunal was premature and that the case could be settled in front of the Special Education Appeal Board instead. Further, they argued that the appeal was not one of the challenging the child's identification, so the parents wrote a letter to the Director of Education in 2001 in June, stating that they were requesting an appeal because the placement was not addressing the child's needs. So it wasn't questioning whether or not the child had needs, it was more questioning how the program itself was dealing with those specific needs rather than their identification. So the arguments made by the child's parents were that they believed they were denied their right to appeal to an appeal board when the TDSB didn't respond within the legislated time to establish an appeal board, and the parents had repeatedly voiced their concern to Mr. Moore, who was an education consultant, that the placement for their child is a half-day placement, and they have repeatedly stated that they want their child in school for a full day. So again, that's the program specifics rather than whether or not the child actually needs to be in a program. The conclusion was that the tribunal agreed with the parents that the needs of the child and appropriateness of the placement are an integral part of an IPRC decision, and that needs and services should be discussed at an IPRC before a placement decision can be made. So in conclusion, thus, the tribunal decided that it did have jurisdiction to hear the appeal. Case number 2 is pretty similar in that the TDSB argued that they, again, had not exhausted all of their rights of appeal, and the parent had disputed the IPRC's confirmation of the child's identification. So it's also different from the first case, where it wasn't just the program that was being questioned, it was the child's identification itself. Since the appellant abandoned the appeal process of this identification before the Special Education Appeal Board can meet, the TDSB takes the position that in doing so, they failed to exhaust all rights of appeal, and again, according to the Education Act, Section 57.3, that the tribunal is therefore without jurisdiction to hear her appeal. So the main issue was whether or not they have jurisdiction to hear the appeal. Karen Forbes, the TDSB superintendent for special education, testified that this was not the first time that the parent had appealed to the tribunal, and the appellant testified that under oath that she did not agree with the identification and placement decisions, and she stated that she made a request for an appeal to the TDSB in accordance with the rules. However, the testimony of both parties showed that both parties contributed to the delay in having the SEAB consider the appeal, and in conclusion, the tribunal found that it does not have jurisdiction to hear the merits of the case, and that they had not appealed all of their other, had not exhausted all of their other means of appeal. So the legal implications involved in both cases were parts of this Education Act, which I'm not going to read out because I have 5 minutes, but they're there. They're basically just that the parent has the right to question the identification, and also in order to question it in front of the tribunal, they must exhaust all other means of questioning it first. Those are other regulations that were involved in both cases. So the significance of the cases to myself as an Ontario teacher: student success is largely reflective of teacher ability, and also students with special needs success is therefore largely reflective of a teacher's ability to accommodate their learning needs effectively. So comparing and contrasting these two cases and the legal implications involved illuminated the challenge that can exist in trying to provide what you think is the best learning experience for a child. Although both parents and teachers typically always want what's best for their children and students, these intentions do not always manifest in the same way. So they might disagree on identification or even just the specifics of a accommodating program in general. So in conclusion, both cases illuminated the importance of clear communication between parents and relevant staff in establishing a need for the identification of a student having special needs, as well as the process that has to be undertaken in order for this to go through. They also presented different but equally significant challenges that teachers may face in recommending that a student be placed in a special needs program. So a parent may challenge the identification of their child as having such needs as a whole, or they may challenge specific aspects of the program and their effectiveness in addressing their child's needs, as in the first case. And there also may be disagreement between parents and teachers surrounding what it is that their child needs or how they can benefit from being identified, because some parents are reluctant to have their children identified as being special needs at all. So the resources are the two cases as well as the specific regulations that I cited from the Education Act. And also I included the link to the Ontario Special Education Tribunals. And I hope you enjoyed my presentation.